right. Good afternoon, everyone. Thank you all so much for joining us for our session of understanding investments. As you know, all of our classes has built upon one another. We learned about budgeting and saving, and then we also learned how to diversify our income. So tonight, we're going to learn how to take care of that income for when we get ready to retire. And it's very important for us to plan, even if we're in college, even if we're in mid-career, and even if we have already retired. So I am going to turn it over to Crystal Broussard.
All right, good evening, everybody. Very happy to be here. I'm just going to do a brief intro on who I am, and then I'm going to ask my panelists to introduce themselves. My name is Crystal Broussard. I am a private client advisor with JP Morgan Wealth Management. I think the reason why I really enjoy doing this work is, again, I love sharing information with our community, making sure that people have access to resources and that can really help them to grow and protect their wealth for now and in the future. So that's just a little bit of my reason why. And I'm going to ask these two lovely gentlemen to share their name, their position, and why they do what they do.
Good afternoon, everyone. My name is Eric Labatt. I'm a financial advisor with Edward Jones here in the city. Been in the role for a number of years, switched from PT to I was a physical therapist for 7 years up until COVID, and then I found a different route. I love this work because I get to partner with my community for their design success and what their life wants to look like, right? I take individual finances into consideration. I want your life to look like your life and nobody else's. So your desired outcomes, that's what I work for.
I am Michael Hall. I'm a family law and succession attorney, and I do this it's a means to give back to my community.
So this evening, we are going to talk about understanding investments, retirement planning, and succession planning. And so we're going to kind of start off with some questions here, but I just want this to know that this is a conversation. So please feel free to, raise your hand if you have any questions throughout the presentation. And we will make sure that we can answer some of your questions and make sure that, again, you have the knowledge and resources available for you to just start planning. So the first question was directed towards me. It says, discuss the importance of crafting personalized investment strategies and how investment goals can shift as clients approach retirement. So just to piggyback off of what Eric said is that, everybody has different goals. And they have different places where they're starting in life as well, different careers, different paths. So you want the strategy to be personalized and geared towards your goals and your lifestyle and what you want to accomplish. And so another point to that, though, is that as you do approach retirement, we're each starting at different stages. We have some that are in college, so you have, you're trying to see and build upon your career, learn about that. There's some of us that are already in our careers, and we have additional responsibilities like family, children, small children that we have to take care of, or sometimes children and aging parents. And then there's those of us who are in retirement that we, and we no longer work, per se have to work a regular 9-to-5 job, but there's still certain things that you want to accomplish and want to do, whether it's, still working part-time because you like doing what you do, or doing charity events, or starting a foundation. As a retiree, it doesn't mean that you necessarily stop living life. It just gives you, if you have a good strategy and good plan in place, it just gives you more freedom and flexibility for you to be able to design your life how you want to, and also to leave a good legacy behind, which we'll talk about in these particular topics. But Eric, want to get from you the key principles of investments and retirement planning, why starting early is critical, and how to balance risk and growth as one nears retirement.
So I go through a 5-step process with all of my clients. I analyze where they are today. I look at where they want to be in the future. I look at can they get there, how do they get there, and then how do we stay on track. That's my role as your advisor, to take where you are today and to map out your life over the course of what you want to achieve. We're talking about goals, we're talking about your life, we're talking about your legacy when you come into my office, and I want to create that safe space for people to be open and honest about what they have and where they want to go in life. So your life is your own. And I always tell a little bit of the story, and I'm going to try not to be long-winded. My cousin and I look like brothers. People thought we were twins. He's married, I'm married. He's on his second marriage. We're 6 months apart. I'm 33. He'll be 34 in December. He has 3 kids by 3 different women. I have no kids, right? So when I look at his life, even though that we look exactly alike, and we come from the same family, our path is not the same, right? So you have to look at your individual goals, your individual life, and say, hey, this is where I want to be. We go through that 5-step process. We analyze your risk because I want to know what your risk tolerance is. I want to know about anybody else's. I don't want to know about your job's risk tolerance or what they placed you in. I want to know about your life and your strategies to build a portfolio and partner with you.
It's wonderful. And Mike, the role of legal planning in ensuring smooth wealth transfer and succession, especially for families with businesses or complex aspects, what is the role of that type of planning?
So with that planning, as I explain this all the time, you remember our last conversation, but as I explain this all the time, everybody should have a will. That's the first thing you should do. Even if you don't believe you have a whole lot in life, you should still create a will. If you have a business or you're a business owner, there are different documents that you should also have, like an operating agreement. Depending on where you are in life, like you were saying, Eric, you should probably consider a prenuptial agreement also. So depending on where you are and what you have, your asset-wise, those things are what's needed.
It sounds like that you want to make sure, just to wrap up this first section, is that you want to make sure that your portfolio is personalized for you, for where you are currently, like starting where you are currently, but building upon the lifestyle that you want and taking care of those important goals for yourself. And you can do that by, again, working with professionals that have the expertise to sit down here and kind of give you the guidance that you need to start on that journey. And they can help you with risk, which really, risk is just a part of how comfortable you are with taking on certain products that, again, might give you a higher return, but they have a risk factor or a risk element to it, but it's about your comfort level with that. And also, succession planning is important because as we grow these assets, you want your wishes to be heard. You want them to be executed. So you don't want it to go, based off of what the state, that may not be how you want your funds allocated, because that is part of legacy planning, whether you realize it or not. So that's the first section. And Candace, you have a question?
Yes. So when we're first starting out, because I know, Eric, you were talking about investing, can you help us understand some of the terminology? You're saying we need to create a portfolio. What is a portfolio? I'm just trying to make $1 million by the time I'm 35. Can you help me understand how to get there?
I could help you get to $1 million if you got about 950 in there somewhere. No problem. By 35, I could do that. But when we talk about investing and we talk about your portfolio, that is your collection of strategies, of stocks, bonds, different type of products, as Crystal alluded to, maybe an annuity, if it's right for you, if it's appropriate for you, right? Which is, I always say that when it comes to certain products, you have to make sure that it's going to work for you and your strategy not for the person that's sitting across from you on the table and is just trying to push their product. So you always want to make sure that you're talking to somebody that is resourceful, that has your best interests at heart, to make sure that your portfolio, your collection of wealth, and how that is going to be distributed into a multitude of categories: emergency cash, retirement fund, travel, any other 529s for college education planning for children, or other obstacles. That is going to be a collection of things we put inside of that. It's tailored to your life.
Any other questions that we have? Yes.
Hi, you spoke about trusting somebody with our portfolio. How will we go about trusting people with our money?
So it's about building a relationship. So I would say that when you meet and you, again, it's okay to vet who you want to work with. As a financial advisor, the attorney, your tax person, it's okay to interview them as well. So I would say that from my perspective, I would concentrate on the questions they're asking you. Like, are they really, asking questions to get to know you better and to really understand, where your values lie, what's really important to you, and are they gearing that conversation towards something that's going to help you accomplish those goals? And it's okay to ask them questions too. Ask them, what's your background? How long have you been in the business? What led you to do this type of, profession? How do you manage your portfolio? I don't mind answering that question either. And I'm sure Eric probably wouldn't either. Any one of us, we should be able to have a candid conversation with you about, what do we do? We don't have to necessarily always go into details or specifics, but we can say, yeah, this is how I invest my funds according to what my goals are, and here they are. These are, and they may not be the same as yours, and that's okay, because we specified, each and every one of us have different backgrounds, different goals, different starts, that we want to accomplish. So, but that's how I would really do it. And again, don't be scared to come in with a list of questions. I love it, and I tell my clients all the time, before we meet, if you have any questions about anything, bring them. If there was something that you heard about, whether you saw it on social media or you read about it and you just want to know more information, bring that. We shouldn't mind answering questions, and you should kind of gauge from their body language also whether or not they're really in tune to you and what you're saying and what you really care about. Any other questions?
Hello. I was wondering what's the difference between a will, a trust, and I heard you say succession, Mike. Give me some differences there.
Take it away, Mike.
I do have a will. My husband and I do have a will. Do we need a trust or do we need a succession? Because in the trust, I'm saying everything I want to happen. I want my children to get the house. I want, they have all my information. So do I need a succession and a trust? Do I need all those things?
No, you don't. All right. So, your will is that one document that tells everybody what you want done when you close your eyes. You say you want this child to have this, I want this child to have that. I don't want this child to have nothing. You can do that too. Your will tells us what you want done. The succession is how we do it. That's when we go to court and transfer ownership. That's what the succession does. It transfers ownership to whoever you left it to in your will. Your trust, I'm not going to say your trust. Trust is a totally separate juridical entity that is completely different and has nothing to do with the succession. So it's really just a juridical entity that's created to kind of house, if you will, assets that you have.
Okay, so I was always told that with a trust, it's good to have a trust because if you do have things like property, that when you leave it to your loved ones, that they could avoid paying like capital gains taxes and things like that. Is that true?
All right. So Crystal and I are laughing because I hate a trust, all right? So here's the bottom line on a trust. Again, a trust is a juridical entity. So if you have one piece of property, you're going to put it in a trust, you no longer own that piece of property. The trust owns that piece of property. I am not a fan of a trust for that particular reason because your property is an asset. Essentially, you're giving your asset away. You cannot use your asset once it's in a trust. That term about avoiding capital gains tax, it's not that much. You have one piece of property. If and when, I'll use you, Ms. Roberta, when you do the succession and your property is transferred to your child or whoever you give it to, there is no tax on there. There is no tax to avoid. Rich people have trust. Why? Because rich people have a lot of assets. Rich people, and correct me if I'm wrong, Eric, but rich people never touch the principal. They live off of the interest. So they can put their assets in the trust and it remains in the family forever. They never touch it because they get, however they have it set up, they'll get their monthly stipend off of that. You got one house. Give it to your child. Let your child do what your child gonna do with it. You dead. You can't do nothing with it anyway. Let your child have it. I know you want to try to protect them from themselves, but if you ain't got it together at 40, you ain't gonna never have it together. There's nothing you can do about that. So again, I personally hate a trust. I hate the idea of a trust. Let me say it like that because people really don't understand it.
And so if you could just kind of walk us through a little bit, what is a will? Because listen, in my young days, I did not create a will. So is it really necessary? And then tell us again what a trust is. Obviously, I'm not a billionaire, so I may not need that, but trust is definitely a buzzword lately. And then again, one more time, like just kind of a definition of succession. I think I get it. Like it's when I'm transferring my wealth, my house, maybe my car, my Facebook login, like all of that is included because that's what I got.
Well, you don't want your Facebook login, all right? We don't want that. We don't want that.
Well, they need to know. They need to know.
But I do want to say, Facebook logins, they're asking you now, like, who do you want to transfer ownership over to? And I did see somewhere, like, people were saying, add that into your will or keep a bunch of passwords, like, especially to your bank account. So outside of Facebook, like, they're saying that we must share our bank account information with someone, etc.
Don't share your bank account information with nobody. No. Here's where you are. Your will is your document. It's a legal document that you're going to create. You and your attorney, y'all going to sit down. You're going to tell your attorney, this is all of the assets that I have. You're also going to say, here are my kids, or here are the people that I want to leave these assets to. So, that's what you put in your will. Your will is just your document that you create. The succession is a legal document that is recorded and filed with the court. In that document, that is how we take what you put in your will and we put it into practice. In your will, you said you wanted your house to go to your 2 children. So, the only way your 2 children actually get ownership is by way of the succession process. Once they have the judgment of possession, it is then transferred, ownership is then transferred to them. They own it. Just because you create the will does not mean ownership transfers when you close your eyes. You effectively still own that property when you close your eyes. Now, that's really not true. Let me say that differently. From a legal perspective, when you close your eyes, there's a term called season. That means the transfer of ownership. It actually legally goes to the kids. And I'm going to say that's in theory. The actual practice of transferring the ownership is when you do the succession. That's the actual formal transfer of it.
So they can't. So if I'm correct me if I'm wrong, but in order for the transfer of assets, the kids would have to open succession. Correct. In order for them to receive the assets officially.
Correct.
Otherwise, they would not be able to do anything with the property, like capture on the value of it, or really with it, because they won't have ownership of it.
You can't do anything with it. It is just there. Think about when Katrina happened, everybody they were living in mama and daddy's house, and then when it was time to go to the insurance company to try to get what you needed to get for the insurance, and the insurance company had to tell you, well, you don't own the property yet. You have to do the succession so that you formally own it. Then we can actually start doing business with you.
All around the city.
This question, if you do not have a will, you die. Regardless, you have to have a succession done. The children will do it, or husband, whatever. You have to open a succession. Am I understanding that correctly?
That is correct. You do have ultimately to formally transfer, yes, you do have to do a succession process.
So if no succession is ever open, your property and everything else is just sitting in limbo.
Yes. For all intents and purposes, in the manner in which you're saying it, yes. It is just, it's there until the formal transfer is done.
So the purpose of the will is saying what you want. And then once you state that, okay, it goes in, I know it goes into the succession. But if you do not have a will, it doesn't really matter, because when you open the succession, everything I desired normally goes to my children, correct?
So, yes, generally speaking, the order in which this would go. When you close your eyes, it would go to your children first. If you have no children, no will created, your parents and your siblings.
And and because we live in the great state of Louisiana, Louisiana is a little bit different than other states. So just to let you know that if you do have family members that live outside, and I'm sure Mike was telling you general, that's probably how it goes across the states, but you still want to get information about that state, because really, when you don't create a will, it's going to go by whatever the state says. If when the kids do, or whoever opens succession. So whatever the state law tells you is how your property or your assets are going to be divided. So just what Micah was saying is that if you want your wishes And the legacy and all the hard work that you put in to maintain, keep the property, keep your assets, that's part of your legacy planning. So I would want my wishes, not the state's, but my wishes to be executed at that point. So that's why it's important to have a will. And to go back to what Candace was stating is that all of the important documents that you have, your insurance documents, your will, your power of attorney, the passwords to your accounts, you need to keep that in a safe place. And yes, designate someone that you trust to say, this is where all of my important documents are. So in case anything happens to me, that one person, or, again, make sure it's a trusted person. You don't have to necessarily have to add account numbers. That's probably already listed in your will when you have one. But you do want to designate a trusted person to know where those important documents are. So again, if something happens to you, they know how to access it, and they can, again, go ahead, and it makes it easier, basically, for your loved ones to really be able to access and start the process. And included in that information should be contact person of your financial advisor, your banker, your attorney, your tax advisor, or tax professional. All of those important people, their contact information needs to be included in that folder or wherever you keep those important documents.
What was my question? Oh, okay. So is it recommended that you start a will whenever you get any form of an asset? And then do you have to have an attorney present for your will to be like contractually binded? Or is it just like you writing what you want, signing your name and dating it?
So I'll start from the back on that last part. There is a such thing as a handwritten will. In Louisiana, it's called an holographic will. It has to be in your handwriting all the way through, your handwriting, your signature, dated. That does exist. I will generally always advise you to go talk to an attorney. Let you and your attorney, again, go through the whole process, getting everything captured that should be captured, every asset, every liability that you may have, things that you didn't think about when you're talking to your lawyer. They're going to bring that up to you. So that's why I would always recommend that you do that particular type. It's called the statutory will. You should always do that.
And
last thing, I'm sorry.
Oh, no.
You said your first question, yes. The second you get an asset, write a will.
And when I will also say this, and this is just based off of experience, because I've seen people fight over grandma's costume. I know it's really, as funny as it sounds, when people pass away, attitudes come out that you did not expect. You're like, I never expected this person. So if you have anything of value that you know that someone would like, even if it's jewelry or a ring or whatever, add that. I hate to say it because I know it sounds tedious, but add that to your will so that there will be less argument. And that's just based off of experience.
You still gonna have arguments.
But legally, that person would receive it.
Okay, I had a question about, so it was mentioned that when someone doesn't have a will, that any of the children can technically success any of the property or anything like that. Let's say my father has a business and my father passed away. And let's say it's me, I success the will, like I success the property first, but then my siblings go in and try to as well. How would that kind of look in a battle and everything like that?
So let me kind of clean up what you're saying.
Yes.
Essentially what happens is this. Once we start the succession process and it's done without the will, again, you're going to sit down and talk to your lawyer, and your lawyer's going to ask you, how many brothers and sisters do you have? Is there anybody else out there that we need to consider? And then when you do that judgment of possession, everybody's placed into possession at the same time. So it's not a situation kind of in the way you were saying it. You went and did yours first, and then they come behind. Everybody's placed into possession at one time.
So do they like divide it off then between the children, or
Everybody's got an
Or-
equal
depending
ownership.
on the shape.
And again, I'm operating under your premise of there was no will. So everybody's going to have, he's got 4 kids, we've got 1/4 interest each.
And does that mean, does that apply to a business as well? Because I know if you have a business and it has its own tax ID number, does that apply then?
If, again, working from the premise that your dad was the sole owner of the business, yes.
Along those lines, what about if the sibling passes and there's one deceased sibling and there's other siblings by the same father but not the mother?
Say it again. There's
Okay.
One,
Okay, it's 3 in the family, one by the mother.
okay,
Okay? One of the siblings is passed, so there's 2. Okay? When one of the 2 passes, does the asset goes to the other siblings by the father?
man, you have confused me. Hold on.
Okay.
All right.
So
Now, hold on, hang on. If I understood what you were saying.
there,
got
we
3
found out there are other siblings by the father. Okay, the mother had 3 kids.
All
Okay,
right.
one passed away.
All right.
Okay, there are 2 left.
Stop right there.
Okay,
Mother had 3 children. One passed away.
Okay.
Did that one have children?
yes,
All right. Is there a will involved?
no,
All right. That one that passed away, her children stepped in for her.
okay. Now, there's other children involved, but it's on by the father, but not with. See, I don't know how to explain.
I understand I think I got you now.
So we
got-
found out. Okay, oh, your daddy had other children. Now your assets have to go to his children as well.
But we're not talking about the dad's succession. We're only talking about mom, right?
Mom, okay.
All right.
I got you.
So you're just dealing with mom.
Yes. She's saying she's just dealing with mom.
So you're only going to be so essentially kind of the short version of what you're saying. Big picture. And we're just going to use a house. That's the only asset we're going to talk about for purposes of this example. Dad owns 1/2 of the house. Mom owns 1/2 of the house. When mom closes her eyes and we do the succession for mom, we're only dealing with mom's 3 kids. 2 still living, 1 passed away. They're entitled to her piece. But again, in your example, I think I'm understanding that dad's children, they're not the same. All right. So that's how that would go. Now, when dad passes away, the difference is you got these 3 over here you got to consider, and those other ones that were over there. So they're addressing dad's 1/2 at that point.
These are some great questions. I like this. I'm learning something too.
Okay, I got another question. So let's say that I know that was said that if no will is involved, the children automatically have the right. What if it's marriage involved? Does the stepmother or the wife automatically take the place of the children, or is it still the children stepping in, or is it based on
Nobody
state?
takes the place of the children. Nobody takes the place of the children.
And to clarify, your will should be like a living, breathing document. Like as you get assets, you should add them on, just like a continuous process.
100%.
So the general rule I tell people, every 2 or 3 years you should update it.
So I have a question. When in a situation where we're talking about a married couple and each couple, this is the Brady's. These are the Brady's, where each person is coming into the marriage with children. So if Mama Brady passes away and there's a house, her 3 children would own their mom's half of the house. Does the husband get a portion of the wife's?
I'm working from the premise that mom and dad own the house together.
Yes.
They bought it together. They both have an ownership interest. No, dad owns 50.
This is
Mom
portion.
owns 50.
Okay.
Okay, let's say that it's a married couple, and the dad, he puts everything in the mom and dad's name, but the mom doesn't put any money into it. It's just dad's money, right? Let's say mom passes away, right? Well, no, mom and dad pass away, but mom has children that are not dad's. But then dad has children that are his. Does his property go towards the mom's children as well? Or because she didn't put in, I guess, monumental value, is her children not set to be one of the successors? They both have outside children.
Hold on. All right.
Yeah, it's like the Brady Bunch, but
But the mama didn't put no money.
Comes in with their children, but none together. The husband and wife don't have any kids together. Mom has hers. So this is the Brady Bunch all over again.
yes, but instead of it being like both of them have ownership, it's like dad has ownership, but he also puts her under.
So first off, Louisiana is what's called a community property state. So what that means is this. Dad is the breadwinner. He go to work every day. Mom is a housewife. Even though dad goes to work every day and mom stays home, every paycheck dad gets, if dad gets a $500 paycheck, and I'm just using that for simple math purposes because I'm not a mathematician here, he get $500. $250 of that $500 that he gets is mom's. So it's community money. So there's no to the point I think that you were trying to get at is, well, dad put in X amount of dollars more than mom ever contributed, so he should have a greater percentage. No, it doesn't work like that.
So they'll still be considered like the successors as well in the past. Yeah, so like both children, all children, mom and dad's children will be considered, or just dad's children.
Well, no, as I appreciate what you're saying. Remember, again, they bought it together, they own it together. Dad's 50. Dad has, I think you said, 2 children over here. Mom has 2 children over here. Dad's children are going to take dad's half. Mom's children are going to take mom's half.
Okay, I got you.
I think we need to do just like one workshop on estates, and I definitely understand why, because it really can get a little confusing with different family dynamics that we're seeing going on. So I would go back to stress to make sure that you definitely speak to an attorney so that you know, again, how the state laws work pertaining to it, and again, the attorney can structure the will for your specifications, so who you want to receive your assets.
And kind of to your point, as it relates to your will, and I was thinking of you, Ms. Roberta, certain things don't have to go in your will, i.e. life insurance doesn't go in your will. Why? Because there's a beneficiary designation. Anything with a beneficiary designation, you do not have to put in your will. Your retirement, there's a beneficiary designation on your retirement. You don't have to include that. It's going to go to whoever is the beneficiary.
I have a box. Right now, I call it in case of death. So they know, all my children know where the box is
And that's how you
located.
got it written, in case of death.
In
on
case
the
of
box.
death. But
My God.
I've been looking at something online that says next of kin. I think I'm going to rename it for the next of kin. And in there, it does have all of the information that should be included in the first thing I have in there, or the life insurance policies where that's the first thing they need to look at. I have my obituary, my husband's obituary. Everything's written out.
You wrote out
I
your
have-
obituary already?
Uh-huh. I wrote out my obituary. I wrote out my program. I know who I want to sing. I know who I want to preach. I know all that's written out. Now, if it's going to happen, I have my outfit also. So all that's done. I have my grave site. All that's done. All they got to do is open the box. They're going to find all the
You got the
information.
songs you want sung in the funeral?
Cat Lee
and
know all that
everything?
already. Cat Lee got all that. I done already told her. So all that's done. Now, if something happens, or somebody that's on the program, they already know. Just substitute whoever. And in the box, I have our birth certificates, social security cards, my retirement information. And in that next of kin box, I did see for someone to have banking information, because when my mother-in-law died, it was total
So
chaos.
glad you said that. Let's talk
because
about that for a second.
our name wasn't on anything. The money was in her account, and we needed it.
So that's the other side of it. The banking information in a situation like that. Now, I know you ain't on that side of it, but there are certain provisions where you have an actual beneficiary designation on your bank account that you can say, when I die, it goes to this person, because that allows, to that point, that person to take the money and start doing what they need to do. Otherwise, if they don't have that, then a man say, we're going to fight about everything, and the bank's going to find out that you're deceased, and they're going to freeze the account.
So I will say this is that make sure that you speak to your bank about the guidelines, because each bank has different guidelines when it comes to that. So with whoever you bank at, talk to a banker about it and say, hey, what are your guidelines? If I pass away, what happens to these assets? Who can I put, can I add, just somebody on here that you could contact or could come in? Ask them how that works, because, again, each bank has their own policies and procedures when it comes to that. And so you want to know what your bank's policy and procedure is, and then you can plan accordingly to what that is.
And please know, Mike said that retirements have a beneficiary, so they don't need to go on your will. I deal with non-specific accounts, retirement, individual investment accounts, charitable trusts, all of these things. Outside of a retirement account, I cannot put a beneficiary on anything. So I work in conjunction with the state attorneys to provide a will for all of my clients so that we know, hey, this is how the assets are to be passed. So if it's not in a retirement account, banking, just like any other investment account, you have to go through the proper provisions, get the paperwork correct, so that you're living and passing along your legacy as you decide.
So does the person have to be with me to do that at the bank?
No,
For example, my husband's name is on the checking account. So if something happened to me, he would be next. But what about my son? Can I
So-
put a son?
So if your husband's on the account and your husband's eyes are still open, then your husband can use the money on the account.
And I would also kind of preference what Eric was saying is that, remember, insurance is also one of those types of products where you can list a beneficiary. And the insurance also, not just in life insurance, but that includes annuities. So annuities, life insurance, and retirement accounts are types of products where you can list a beneficiary. So you don't necessarily have to put that in a will, because, again, the companies are going to go based off of who's listed as beneficiary. And so what I do with a practice that I have and I encourage clients to do is that every year you should have an annual review with your banker, your financial advisor, your attorney. just like you meet with your tax person every year to file taxes, that's the time when you need to meet with your financial advisor and your banker as well to make sure that your beneficiaries are all and insurance, also your insurance specialist or insurance agent if you have it. You want to check all of those accounts on an annual basis, as well as looking at your will. Review it annually to make sure that the beneficiaries are listed according to your specifications, as well as you are reviewing your will, because, you know, if we honest with each other, once you have it set, you kind of forget it. You put it in a box. Like you say, you mark it, but you don't review it. And then 5 years later, it's like, oh my goodness, I don't know. I think it's that, because we forget. We got so many things going on in life that you know, can sometimes fall through the cracks. But I encourage you, and a simple thing is when you're doing your taxes every year, make sure that you're having an appointment with your banker and your financial advisor to review your portfolio, you know, or your assets, all of those things, but also just make sure that, again, you're reviewing the beneficiary information as well. And we got 5 minutes left. We didn't get through all the questions, but I like this on state.
Hello, how you doing? I'm Sydney Jones. I was just wondering, say someone is left off of the succession, is there like a time frame to where you have to update that succession, or is once it's done, it's done?
So when you say left off, give me a little bit more on that.
Like say it's siblings, and one of the siblings was left off of or one of the siblings' wives was left off of the succession. Would they have to update that, or?
So you can come back in and amend the judgment of possession if somebody's left off. 5-year period. I believe I'd have to go back there and look at the code, but I believe it's a 5-year period.
Thank you. Oh, I'm sorry.
I don't know what she meant. I'm sorry.
There's a husband. The husband passed, and he has brothers and sisters, but also has a wife that's living. Does that wife belong on that succession, or?
So that's what I was going to say to you. Now, it's not an automatic that the wife gets something. And I'm going to just kind of leave it right there to say it's not an automatic that a wife gets something. You can raise your hand. It's not an automatic that your wife gets something. Case in point, if the brother did a will and said, I'm leaving everything to my siblings, he can do that. The wife is not what's called a forced heir. So it's not an automatic, and that's what I'm just saying, it's not an automatic. We would have to look and add it a little bit more to kind of get into that.
I'm confused.
Yeah.
If they're married,
Mm-hmm.
so we're talking about, right, the husband and wife.
Okay.
The husband dies. The wife has to get 50%.
The wife does not have to get 50%. I can write my will right now and say when I die, I give everything to my 2 kids. Because what happens is, no. See,
You know
I'm
going to check that out. You know.
You can check it. I'm taking the premise of, so kind of, let's use our house as the example. You and husband purchased the house together. You already own your 50%. I own my 50%. It's not an automatic that you get my 50%. You get what I'm saying? So that's why I'm saying we would have to look at it to see because the wife may not be entitled to what we thinking the wife is entitled to.
If you married me and we lived together and We all put money in this house. 50% is mine.
That's your 50%.
That's all
That
right.
is not my 50%.
No, I don't care about yours, baby. I'm talking about mine.
But that's where the question and where we were going. I don't have to leave you your 50% because you already own your 50%.
I don't care if you give it to who you want. I don't care, but mine. But anyway, I have one more question. Let's say I'm not married, well, I'm not, but I was living with someone and lived with them for 15 years. And we've lived in this house, we bought this house, and he dies. Would I get that house, or would he have to put that in a will in order for me to get my portion of it? In other words, would the house go to me? No children involved, just dogs and cats. So
y'all are simply co-owners under the example that you gave. Y'all own the house together. You own your 50%. He owns his 50%. He didn't have a will. There are no kids. There's no anything.
Okay.
So if he's got brothers and sisters over there, his brothers and sisters get his 50%. In order for you to get his 50%, he would have to create his will to say, I give my 50%
Okay.
to you.
Are we going to do one more question, and then we're going to wrap up for the evening?
I have a question because I'm in that situation with the succession, but my siblings don't live here. And I don't know, can I proceed to do it without them? Or do I have to wait till I go get one of them?
You can start the succession. You can open the succession. You can start doing things. Your sisters and brothers will have to be joined in to say they acquiesce to the succession process or they
But I
object
can
to
start it.
But you can start it, yes.
Thank you. I needed to know that. It's amazing that y'all talk.
All right. So, Candace, do you want me to kind of just do a briefing, or you want to? Okay. So this was, I mean, again, I love the audience. I love the questions. Y'all had some really good ones. Mike is the star. Was the star this evening, but it seems like we need to do just like a session just based off of succession and estate planning. But Mike is available for you guys to get his information for sure if you have any additional questions. So is Eric, if you have any questions in regards to, investments and beginning investments, and I'm available for that conversation as well. If you have any questions in regards to investing or how to start on that. But basically, what I'm getting out of it is planning is key. And getting experts involved in your conversations or in that early or as soon as possible is also key. So, when you're talking about building your assets and they're going to grow and where you are, you need your team of experts. Your team of experts will, of course, be an attorney, a tax advisor, a professional, and a financial advisor. This is your team that's here to work on your behalf to make sure that your investments, your assets are working towards your goal and what you need in whatever you want or desire to do, and to also make sure that your legacy is passed on how you want it to be passed on. Because as we all discovered, we all come from different family backgrounds, different family situations, and so we want to make sure that we have those conversations. So thank you so much for joining this evening. I appreciate this audience. Y'all are awesome. I hope that we could come back and do it again and talk to you guys a little bit more about it.
Thank you all so much. And yes, we'll definitely need you to come back because we definitely have a lot of situations in 2024. But please join us next week as we have our last session. And we will also get another session and talk about more of succession investment, invite a CPA out here as well. So thank y'all so much for coming out, and we'll see you next week.